Okay, I'd like to say good afternoon. Thank you for braving this session. I know I'm between you and the bike ride, so you may want to stay in here and keep warm. I'm Sarah Faulder, Chief Executive of the Publishers Licensing Society, and we're delighted to be sponsoring this ALPS conference this year. And thank you very much for inviting me to speak. As trailed, I'm going to talk about a very specific issue within collective licensing and explain why it's important to publishers. It's both important for the principles at stake and for the money that is at stake. But before I go further, could I just see by a show of hands how many of you are familiar with collective licensing? Okay, that's good. Excellent. Now, as you can guess, there are two chairs here, which means I am going to invite someone to join me on stage a bit later on, so you don't have to listen to me for the whole session. It will be James Perham-Marchant from Wiley. He is Director of Government and Academic Affairs at Wiley for Europe, Middle East, and Africa. So, that's not a good start. Oh, yes. I'm going to talk about a number of issues before getting and setting everything in the context of the economic background to give you some perspective on why all this matters. So, first of all, I think it's really important to understand the importance of copyright in all of this. Copyright, of course, is at the heart of publishing, and it's what enables publishers to protect their investment and to generate a return on their investment. Now, when you talk to government about any changes in the law, they always want to know how much your sector is worth to the economy. And I think we can tell a pretty good story with copyright. The publishing industry is part of the overall copyright industry. And in terms of jobs, you can see up there that the copyright industries, and of course that it covers film, music, software, as well as publishing. Publishing is an important part. They account for 7.1% of jobs in the whole of the European Union. And all IPR-intensive industries, which include patents and trademarks, account for 38.1% of employment in the European Union, which is incredibly significant. So, in terms of value, what's it worth in terms of euros? Again, very significant. Altogether, 42.3% of the worth of the European economy. And according to the statistics of another trade association, the Publishers Association, over half the turnover of the UK publishing industry is attributable to exports, and that's another area that government is really interested in. Importantly, the IP industries in Europe accounted for most of Europe's trade with the rest of the world and generated a trade surplus. So for all these reasons, I think if publishers and other copyright owners have concerns, we have a right to be listened to and taken seriously, and indeed we are listened to. So moving on to the issue of the day, why do we need to talk about levies? For several reasons. Levies were worth 635 million euros worldwide in 2015. And for publishers and other right holders, they are a very important source of revenue, and I'll go into that in more detail in a minute. They were introduced as long ago as 1985 in some countries, so they've been around for a good 30 years. There have been a number of attempts to harmonise the law around levies, at least in Europe, because it's a very complex web. Every country has its own rules, and it does add complexity for those who have to pay the levy, and I'll come on to who they are in a minute. But for the reproduction rights organisations, the RROs, as we call ourselves, and PLS is one of those, when this works, yeah. Levies are actually the backbone of a number of the European RROs. It's a very important, significant part of their work. That's not true of the UK, and I'll explain why a bit later. But we do benefit from the money. So we're going to be looking at what happened, what's gone wrong in the courts recently, given that all this has been in place for some 30 years, and also at what we're doing to try and get things back on track. So just to explain a little bit more about what levies are, they're a means of compensating right holders for the free use, otherwise free use of their content under what we call exceptions to copyright. And they usually apply where it's very difficult to actually license directly. So if someone is copying at home for private purposes, there's no way that anyone can actually control that and monitor it. But it's only fair that the right holders should be compensated in some way. Levies are actually payable by the people who manufacture or import devices that enable copying. So it's not the users themselves, it's not the people at home who are doing the copying, but it's the people who manufacture the means by which that copying can take place. And there are two forms of levy. One is the equipment levy on the device, and one is called the operator levy, which applies to copy shops and other large-scale users. So what are these devices that attract levies? There they are, pretty long list, and pretty obvious. Most of them have some sort of means by which copying can be undertaken. But this list is not applicable in each and every country. It varies from country to country. And as technology develops and more devices encompass some form of capacity to copy, so the number of devices in that country attract a levy. But it doesn't happen automatically. It happens usually as a result of litigation taken by the RROs against the equipment manufacturers to try and establish that something should attract this levy to go back to the right holders. A good example was recently in Germany, where Wort, the German RRO, had a win a couple of years ago in which they established that printers and PCs should attract a levy. That decision was backdated to 2001 when they first started the litigation, and as a result, the equipment manufacturers, the manufacturers of the PCs and printers, had to pay a very large sum of money to Wort to cover all those past years. Obviously, they'd been providing for that over the years, but it meant that a very large lump sum came into Wort in one go, which has now been distributed to RROs around the world, and we at PLS distributed our share of that onto publishers in the UK just last September. And I'll explain why it's taken that long in a minute. It's because of the courts. So I've mentioned earlier that levies were worth £635 million around the world in 2015. 91% of that came from countries within Europe. and not all countries, but most countries. So the systems around levies, the legislation, the case law, the practices have all been really largely shaped and developed within Europe over the years. And it's interesting to look at the per capita rate of collection of levies around the world, which varies hugely. So the average rate across all countries that have levy systems, and not many countries outside Europe do, is 58 euro cents, whereas the average rate in Europe is much higher at 1.42 euros. Bear in mind that this is a pot of money that is collected from equipment manufacturers. Legislation in many countries requires a percentage of that pot to be applied to social and cultural issues. Now, what are those? Generally, the social application of these funds usually ends up applying to pension funds for the officers and board members of the collecting societies. And the cultural application of the fund is usually towards matters of cultural projects that benefit all the right holders within a particular sector. And the average deduction across all countries is around 10%. But you'll see how that varies in a minute. But that social and cultural deduction is taken off before any money can be distributed on to the right holders. So just taking the top 10 European Union countries for levies, this is how they stack up, with France way and above, ahead of all the other countries, and interestingly collecting at a phenomenally high rate of 3.38 euros per capita. It drops very quickly. Number 4 is the Netherlands. We're here in the Netherlands, and there's a big difference between what's collected in Germany and in the Netherlands, as you can see. And then it drops right down again when you get to number 10. These top 10 European Union countries account for 90% of the levies collected around the world. Generally, after you've deducted the social and cultural deductions, these monies are divided equally between publishers and authors. I'm talking here about levies, obviously, for text and images only. Levies have been in place for much longer for recordings and for music, because we've sort of rather come in late in the day, because it all follows on from the development and involvement of photocopying in the 70s. So actually, what is all this worth to publishers? Why should you be concerned or interested? A very rough estimate of what that is worth to publishers is about 244 million euros. Bear in mind, and then if you add probably another 30 million euros, it's not far off, for levies collected from the other countries, that's 275 million euros to publishers alone. It goes straight to the bottom line of publishers. You don't have to do anything for it. You just have to provide your bank details, and the money will be transferred into your account from these levies. So if you factor that in, it's probably worth 8 to 10 times that number of 275 million euros. So it's worth talking about. So how does all this work? Essentially, the governing law around levies is currently enshrined in the Copyright Directive of 2001. Bearing in mind, I mentioned earlier, I think, that levies have been around since 1985, the directive is quite late in the day, and that's going to be significant in a moment. But we have had levy systems in Germany and France since 1985, in Spain since 1987, Belgium since 1994, and so on. And how it works is that under the directive, member states can introduce exceptions. They are not obligatory, they're optional exceptions. And they're exceptions to the exclusive right of right holders to copy, the exclusive right of reproduction. So what it means is that these exceptions allow anyone to copy within these limited means, i.e. make photocopies, paper copies, or copy for private or non-commercial purposes, providing the right holders receive fair compensation. The levy is the fair compensation, and that is a big condition of these exceptions. The other important part of the exceptions is that they are subject to what we call the Byrne three-step test, which basically protects the legitimate interests of copyright holders to make money out of their copyright. This is why these exceptions only apply to non-commercial use, not commercial use. So what is fair compensation? There's actually no definition in the Copyright Directive, but it does say that a valuable criterion for evaluating what an appropriate level of compensation should be is the possible harm to right holders resulting from such use. How do you measure that? How do you quantify that? We don't have any guidance. But these systems have worked over the years. The levies have been collected, and right holders at least feel they've been getting something for the otherwise free use of their content. I'd like to just take a moment to talk about the UK, because we are significantly absent in the world of levies. And this dates back to our Prime Minister, Margaret Thatcher. In the early 1980s, the music industry was trying to introduce levies on blank tapes, because they said that blank tapes were killing music. And Margaret Thatcher decided that this sounded to her like a tax, and she didn't want to introduce any more taxes. And so she absolutely banned levies almost from the language. So everyone's been living under that shadow ever since. And what it means is that although these levies are being collected around Europe, we're not able in the UK to collect any levies and offer them back to member states for the use of their content that is being illegally copied in the UK. So eventually, in 2014, the UK government decided it would introduce an exception to legalise private copying, but in their wisdom, they decided that there was no harm to right holders that should be compensated for, because this illegal copying had been going on for so long that the industries had clearly survived. The publishing industry, the music industry were clearly still fighting fit. So they didn't even introduce a mechanism for calculating that harm. Not surprisingly, the music industry railed against this and immediately subjected the government to judicial review. And indeed, the court said, no, this was completely wrong under the Copyright Directive. There had to be provision for compensation, and the government quickly withdrew the exception. So we were back to square one, and with no means of enforcing this right against people who were busy copying in private, and there was no way of getting any compensation back to the right holders. So clearly some form of levy could have been helpful and would have been pragmatic, but our cries were falling on deaf ears. So who benefits from the reproduction right under the directive, bearing in mind that it's the exception to the reproduction right that is subject to fair compensation. There's the list. No mention of publishers. Now, publishers had always benefited from levy schemes since 1985. We do know that authors assign and transfer their rights to publishers. Publishers become the copyright owners for all intents and purposes. And they are recognized as right holders under other European legislation, particularly something called the Collective Rights Management Directive, which was introduced in 2014 to regulate RROs like PLS. So that is just a point to tuck away until later. So what happened was that there were enormous tensions, as there always have been around levies. The tensions between Hewlett-Packard in particular and Reprobel, the Belgian RRO, exploded into litigation. And during the course of that litigation, Hewlett-Packard were trying to resist having to pay levies on yet more of their devices. And Reprobel was constantly trying to keep the rate of levies as high as possible. So they came to blows. Some questions arose during the course of that litigation, which it was decided should be referred up to the European Court of Justice for interpretation. And what the European Court of Justice decided was that when you look at that 2001 copyright directive, and specifically at that list of right holders, of course, publishers are nowhere to be mentioned. Ergo, publishers are not right holders within the meaning of the directive. There is no obligation for them to ensure that authors benefit from any compensation from levies, and they therefore do not suffer harm for the purposes of the directive and should not have any share in those levies. This decision, as you might imagine, sent absolute shockwaves through the RRO community, who happened to be gathered for their International Congress in 2015 in Mexico City. I've never seen so many glum faces as after that decision was delivered. No one was expecting it to go that way. It has lots of ramifications, but importantly, it really introduces, it's divisive. Collective licensing is is one area where authors and publishers have worked pretty effectively together. They have a common interest in trying to make collective licensing work, generate as much revenue as possible. And this just just divided them. So we've had to work very hard to keep the authors and publishers in the collective licensing community pulling in the same direction on this. Unfortunately, I heard only this morning that there is still a group, an important vocal group of writers that actually are very against publishers continuing to have a share of these levies. So, as if that wasn't bad enough, in Germany, Herr Vogel, who is an author himself and a member of Vage Wort, had brought proceedings against Vage Wort, challenging the distribution to publishers. Now, this case concerned the interpretation of national law, of German law, and the rules of Vage Wort. But for some reason, the German courts thought they should wait and see what happened in the Reprobel case, and then, having heard what happened, they decided they should follow it and say that publishers were not entitled to a share of the levies. This decision got worse because it has retrospective effect, and Vage Wort found themselves in forced into starting to have to reclaim levy money that they'd been paying to publishers since 2012. This actually has driven some German publishers into bankruptcy. Others are in severe financial straits as a result of it. There was an attempt to try and get the authors and publishers, members of Vage Vort, to agree that this, the publishers should continue to get their share. That failed due to a very small number of journalist members of Vage Vort who, in fact, don't even benefit from the levy. They're not participating. So that was scuppered. This decision has also been felt in the music industry. So GEMA, the German collecting society representing music publishers and songwriters and composers, found themselves ending up in a similar position. There was litigation and they had the same result. So the consequences have been quite severe. Distributions were frozen for a long time. Some RROs suspended all distributions. Others decided they could distribute, but only to authors, not to publishers. Monies were not being distributed to overseas RROs, so CLA, which is our licensing agency in the UK, was not receiving the monies from Vage Vort for some time. Publishers were facing the prospect of losing a very large, significant amount of money. We had the issue of damage to author-publisher relations. It was potentially very damaging for the whole world of collective licensing because a lot of those RROs depended on administering the levies. And it had wider implications for publishers. If they're not considered as right holders under European law, where does that leave them? So that added impetus to the discussions then going on, bearing in mind the German decision came out in April of last year, April 2016. And there were discussions about introducing a new publisher's right. And some felt that if we had that in Europe, that would solve the problem. Others felt that wasn't exactly the right way to solve it. So there was a lot of debate. And eventually, in September 2016, exactly a year ago, actually probably to the day, I think, the European Commission introduced its draft copyright directive for the digital single market. Now, when this problem first arose, we went to the Commission and said, look, you've got to fix this problem. European law is not right. They said, nothing to do with us. It's down to national legislators to introduce law to sort out the problem. Naturally, the German and Belgian legislatures didn't want to infringe European law, so we were in a complete impasse until President Juncker made a useful statement and said that he actually wanted to see not just journalists and authors, but also publishers fairly paid for the copying of their content. So, in the directive, we now have, it's a draft directive at the moment, we're going to hear more about that in a minute. We have a provision which says that if an author has transferred or licensed their rights to a publisher, that is sufficient to enable the publisher to make a claim on the levies. In the meantime, in Germany, they introduced something they regard as a temporary solution, which allows Vage Vort to distribute money to all its members. So the fact that its members include publishers as well as authors, they are allowed to distribute the levies to both, but the situation is not as clear as it might be. We still need the legislation in Europe. And in Belgium, the Hewlett-Packard and Reprobel case went back to the Court of Appeal in Brussels. And interestingly, when the court looked at the Belgian law again, they said, well, actually, this remuneration going to publishers is not paying them for their copyright interest, it's paying them for their investment in producing that content in the first place. And therefore, the Reprobel can continue paying the publishers. At last, a good outcome. But again, nothing is really on the firm ground that we would like it to be. So that brings us up to the European Copyright Directive, which I'd like to invite James to join me on stage. And we're going to talk a little bit about it. And as he's coming up, just to say, Article 12 is probably the least controversial provision in this directive. It's a hodgepodge of provisions. It's looking good at the moment. There have been very few amendments to it, although the Estonian presidency has said they would like to extend it to public lending right and make sure that the publisher's share to that is enshrined in this provision. I'm not sure that that will succeed. It's a slightly different issue. But the disappointing news, as I said this morning, was that I heard that there are some authors still wanting this provision to be deleted altogether. So we're still trying to work together, but it's proving quite difficult. Now, you've heard enough from me. I'd like to just ask James to talk about another really important provision that is in this directive. And perhaps you could talk a little about the acronym up there, which is text and data mining. And I'm sure a lot of you will have heard about this, but
Thank you very much, Sarah. I'm conscious I've only got 8 minutes till I'm supposed to rush upstairs and get into my sporty gear and be drenched by the beach. So I'll try and keep it. You're such a good sport. I'll try and keep it relatively short. I mean, just by way of introduction, I mean, my role as Director of Government and Academic Affairs at Wiley involves spending a lot of time in Brussels, which used to be challenging, but now being British is even more challenging for reasons that I needn't go into. I mean, at the moment, what we have with text and data mining is, as Sarah says, it's one of many kind of sub-proposals within the European Commission's Digital Single Market package, as it's known. It's been drafted by the European Commission, and as it currently stands, the text provides an exception for copyright to reproductions made by TDM for research organisations, which has been defined reasonably clearly. And those research organisations, however, would cease to be beneficiaries of this exception if they engage with commercial entities who have a controlling interest in their activities. Presently, this exception is restricted to not-for-profit organisations, and it doesn't create the presumption or precedent of an exception broadly applying to all works on the internet. However, the Commission is only the first stage in the process of drafting EU regulations, and so the second stage, which is where we are at now, is the kind of process of scrutiny by the European Parliament. And I won't bore you with the acronyms, but there are 5 European parliamentary committees currently producing or already have produced opinions on the entire Digital Single Market, or DSM for shorthand, proposals. And those are the Industry Committee, the Consumer Affairs Committee, the Culture and Education Committee, the Civil Liberties Committee, and most importantly, and the one which hasn't yet pronounced, the Legal Affairs Committee, or jury, to use its acronym. And that hasn't pronounced for a number of reasons, one of which is the fact that the former rapporteur of the committee, a Maltese MP, chose to return to Malta to re-engage in domestic politics after their election earlier this year, and has now been replaced by a German MEP from the kind of EPP, or the sort of centre-right coalition within the European Parliament, Axel Voss. The good news from our perspective is he's seen as being more receptive to and friendly towards the publishing community than his Maltese predecessor. But the European Parliament is always very keen to sort of flex its muscles and make sure that its opinion is kind of reflected in whatever emerges by way of regulation. So we are still having, as an industry, to lobby very hard around this issue. And when I say we as an industry, The principal protagonists have been the International Association of Scientific, Technical and Medical Publishers, STM for short, along with a number of the larger publishing houses, notably Elsevier, Springer Nature, Wiley. And I think I'd like to make a heartfelt plea to those in the room to, where possible, become engaged in policy debates in Brussels. They may sound fairly turgid and dry and dull, but as Sarah alludes to, they do matter for the future of the industry. And what I've found over the years going to Brussels is that actually, you know, rightly or wrongly, a lot of policy makers are pretty fed up with having to sort of sit down for another meeting with Elsevier or Wiley or Springer or STM. They're really interested, however, in the voices of smaller publishers, and particularly in the voices of learned societies. At Wiley, we take over a delegation of learned society publishing partners every year to Brussels. And it's just astonishing to see how engaged European parliamentarians become with learned societies, because it's a sector they know very little about, and they're always really interested to learn about a lot of the very laudable initiatives that learned societies are doing to improve society as a whole. So in terms of the time frame with the text and data mining proposals, the latest intelligence, and this is just from yesterday, is that the Legal Affairs Committee will not actually come up with an opinion until December at the earliest. And what that means, in short, is that they're still unsure of which way to go with this issue. I mean, one of the kind of realities of advocacy in Brussels is that you often have a very polarized spectrum of opinions, and it tends to be the people at each end of the spectrum who shout loudest, and that leads to a lot of kind of confusion amongst the MEPs who, you know, by virtue of their role, are kind of humble generalists. I mean, you would find very few MEPs in the European Parliament with any kind of background in publishing. Some may have an academic or research background, but again, it's a very small minority. So I think what we are likely to end up with, however, and this is my best guess, is that there will be an exception for text and data mining. It is likely that it may go beyond what the Commission has proposed, i.e. text and data mining by research organisations being included in the exception. It may go and also include startup and incubator organisations, which are defined as having under 10 employees and a turnover of less than 2 million euros per annum. Or it may even go further to embrace parts or all of the SME sector, however they choose to define that. It probably won't go as far as to include AstraZeneca or GlaxoSmithKline or sort of big pharma companies. And that would be fairly catastrophic from our perspective, I think. But I think one of the reasons Sarah asked me to come up here was to just provide some context that actually the publishing industry is sort of alive and well in Brussels. We are doing our best to and I hate to use the word lobby, but to lobby on this issue. But that actually, at the moment, we're only representing, you know, one sort of end of the industry, i.e. the kind of larger global and international houses. And I think it would be very beneficial for, you know, other parts of the publishing community to, where possible, engage with Brussels. I mean, I recognize it's not necessarily on everyone's sort of travel itinerary, but it is quite a nice city from someone who goes there about 30 times a year and is probably a bit jaded with it, if I'm being honest. So I think that's where we are. In terms of the time frame, I suspect that the parliamentary opinions will all be available by the early part of next year. And then it goes into, and this is a classic Brussels term, the trialogue, which means essentially a three-way debate between the Parliament, the Commission, and the Council of Europe, i.e. the representatives of the still 27 EU member states. And from all of that and various smoke-filled rooms and horse trading and bargaining, something will emerge. But I do stress that actually a lot of people overlook the importance of the member states in this process. They focus almost exclusively on the European Commission and the European Parliament. But actually, the Council of Europe has an equal say in this. And so if you do know local policymakers or local ministers, then please do sort of reach out to them and try and get your point of view across on these digital single market proposals, because they are going to be key and they will certainly be in play within, I would say, 18 months. At the moment, as Sarah said, Estonia has the presidency. The next two presidencies are Bulgaria and Austria, and then after that, Romania and Finland. So those are the countries that will play a pivotal role in steering this legislative process and coordinating it over the years. So again, anyone with contacts in those countries, please reach out to them. I mean, the one country that should have the presidency at the moment is a certain United Kingdom, but because of events of last June, that was passed over to Estonia. So unfortunately, from the perspective of the publishing industry, the UK is not really a significant influencer or player in this, and that's rather unfortunate because in the past, UK MEPs were a very valuable kind of interlocutor and conduit for the industry to get its views across in Brussels. But sadly, we are now having to build broader alliances. Sarah, I think...
Thanks very much, James. So just to wrap up very quickly, because that gives you a very good flavour, I think, of how one issue is being tackled. And there are other issues in this directive that affect publishers directly. The education exception, which we as ROs have been deeply involved in, which is being modelled on what we have in the UK at the moment, I'm pleased to say, which is an exception subject to licence. The digitisation of out-of-commerce works by cultural institutions and having extended collective licensing for those, a special right for press publishers for digital uses, the use of protected works on platforms, and so on. And there are even issues that, to our mind in the UK, are contractual issues, but they want to get involved in issues between authors and publishers in their contracts, which we feel is completely out of place. But so there are many, many things to be looked at, and there we are. James has sort of summarised the process. So thank you all very much for listening. Now, I fear I've run out of time to ask you questions, but or to let you ask questions rather. But sorry. Oh, we can. Okay. Are there any burning questions?
Thank you. If you get a European legislation before Brexit, will this be translated into UK law?
Yes, I was actually just going to kind of add that codicil at the very end, that I mean, the likelihood is that this process, it's already seeming to be more protracted than was originally envisaged because of the difficulty of the parliamentary committees to get their head around some of these issues, frankly. It is likely to, I suspect it will be, the form will be known by March 2019. And I think given the government's position that the UK government is in at the moment, the almost 100% likelihood is that if this is on the statute books by then, it will be transposed in its entirety into the kind of UK law. However, it does apply, this regulation applies for a one-year transition period. Now, again, timing-wise, the UK is likely to have left the EU, presumably, although, again, I wouldn't like to be on record as to whether I think that will happen or not. Presumably, the UK is likely to have left the EU by the time that transitional arrangement comes into play. So at the moment, I don't think I have any more idea than the next person as to how, in a practical sense, that would happen. But in terms of the digital single market, it would clearly, I think, be pretty insane for the UK government to try and take a different position. So I suspect it will just transpose it in its entirety.
And bearing in mind that the basis of the TDM proposal and the education exception are very close to what we already have in the UK, I think, you know, that...
Yes, I mean, they go slightly there. I mean, the proposals at the moment go slightly beyond it because the UK, it's only UK and France currently that have an exception, a copyright exception for TDM, and they're both very narrowly defined as being for non-commercial purposes only. As I alluded to, there may be some creep into commercial, but only probably at the start-up, incubator, possibly SME end of the spectrum. But I think, I don't think the Commission will be going beyond that.
No.
Hi, James.
Hi, Roy.
Roy.
So, question for you, James. So, you know, with the likelihood that the TDM exception creeps into whether it's small and medium enterprises or startups, what do you think is the risk that the commercial entities can then just turn to using those startups or SMEs and get a backdoor exception that also spares them having to buy journals?
Well, I mean, Roy, it's obviously something that we're fearful of, and it's a very valid point. I mean, one would hope that, I mean, we have already made the point to the policymakers that this is a potential scenario. So one would hope that the kind of drafting of the regulation is sufficiently watertight that it kind of doesn't allow for that to happen. We've certainly flagged that as a concern already.